So the person you're accused of hitting, well, now that I've found you guilty of hitting and that you've pled true, you pled guilty of hitting. Did you love that person?
Honestly, yes, I did at one point.
Well, I mean, when people say honestly before something, usually what's coming is dishonesty.
A single answer can change the tone of an entire hearing. This defendant tells Judge Boyd he once cared about the person at the center of the case, but the way he says it makes the court stop and look closer. From there, the hearing becomes bigger than one plea. Judge Boyd starts asking what his choices taught the people around him, and whether court supervision can actually force a different path. Watch how one answer turns into a full courtroom warning.
2024 CR 011907, State of Texas versus Gabriel Zamora. Can I have parties announced for the record for the state?
Defendant for the state of Texas.
Defense.
Albert Chidas for Mr. Zamora.
And are you Mr. Zamora?
Yes, Your Honor.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor, and yes, we did.
Court will find that the state is in compliance with discovery. Mr. Zamora, did you review the document entitled Application for Community Supervision with your attorney? Did you understand it and sign it?
Yes, Your Honor.
And off the record, and I do have Crispin, I'll take that up. Okay. We're back on the record. Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
And indictment to correct the previous conviction the defendant has for assault to July 17, 2018. Furthermore, we're moving forward on count 2, only waive count 1.
And we have no objection to that, Judge.
Did you review court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with assault family household member with a previous conviction as a third-degree felony? Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
He was.
Mrs.
Was.
Zamora, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promise you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 4 years in the prison. State is proceeding on count 2. There's a $1,500 fine. There is no application for deferred adjudication. There's an affirmative finding of family violence. There's to be no contact with the complainant. There's to be a mental health evaluation. State recommends community supervision. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, Your Honor.
Did you understand with an affirmative finding of family violence, you're not allowed to own? Did you understand with affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, Your Honor.
Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 4 years. There be 150 hours community service restitution, the BIPP course, TAP evaluation, and to follow all recommendations. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to count two in the indictment, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence?
The time state moves to admit state exhibit 1 with attachments.
No objection, Your Honor.
All right, and state, have you talked to the complainant? All right, state, you may be excused. Did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
We are, Your Honor. We also have a request. His parents are here. They're divorced. He wants to live in Natalia with his dad.
Mhm.
So we would just ask if the court would give him permission to either report in Natalia, report here, but live in Natalia.
All right, how far is Natalia
About
from?
25 miles or so from here.
Okay, yeah, he can remain in Bear County. All right.
Thank you.
So are you employed?
I have my own business,
Doing what?
renovation.
Do you have any children?
I have 6.
What are their ages?
I'm about to be, it's 10 all the way to 2.
No.
10, 5, 4, 3, and 2,
All right. Boys, girls?
3, and 3.
All right. So the person you're accused of hitting, well, now that I've found you guilty of hitting and that you've pled true, you pled guilty of hitting. Did you love that person?
Honestly, yes, I did at one point.
Well, I mean, when people say honestly before something, usually what's coming is dishonesty. So you hit her. Now, let me ask you this. What if your daughters were to end up with somebody that they say they love them, right? And your daughter's completely in love, and that guy is hitting on them. How do you feel about that?
Break my soul.
Well, so you broke somebody else's soul by hitting on their daughter. And let me just tell you, children learn how to speak and about relationship from their parents. So who knows? I hope it doesn't happen, but your daughter, if they've seen any of this, or your children have seen you being abusive to any female, guess what they're going to think? They're going to think, well, my dad loves that person. So my husband, my boyfriend, if he hits on me, that's just showing that he loves me. And you know what the boys are going to think? They're going to think, maybe this is how you show you love someone, or either they're going to think might makes right. That's how we win an argument. You beat somebody down. You're going to have to change your ways. Last time, the conviction that's here, somebody gave you 1 day in the Bear County Jail for assault bodily injury. That's somebody else. What I can tell you in this court, and deputy will tell you, probation is not easy. Probation is not supposed to be easy. It's designed to rehabilitate. And you're going to have to start figuring out why you are abusive towards people that you claim that you love. You understand? There's going to be a $1,500 fine that's going to be probated. I'm going to sentence you to 4 years in the prison, suspended and probated for 5 years. There's 150 hours of community service restitution. I'm going to order parenting classes. Once he completes parenting classes, that will be deemed satisfied. How far did you go in school?
Like 9th grade.
All right. You're either going to, let me rescind that. So it's 100 hours of community service restitution. There's going to be 50 hours will deem satisfied for parenting classes. And the remainder 100 hours, if you are in some sort of trade school and you complete that, then I will deduct the remaining 100 hours. If you do not, guess what? You're going to have to work those 100 hours. You can either work those 100 hours for somebody else or work it for yourself. You understand?
Yes, Your Honor.
There's to be regular reporting by Zoom or in person, regular random UAs. He's not allowed to reside with minors. There should be no unsupervised contact with minors. So with your children, in order for you to have contact with them, there needs to be an approved adult. Do you understand?
Yes, Your Honor.
There's an affirmative finding of family violence. There's to be no contact with Rosalind Torres. And there's to be proof of employment within 30 days. You need to get a job where you have a regular paycheck. You understand?
Yes, sir.
There's to be no employment as a home healthcare provider or with minors. The BIPP course. And we'll do a TAP evaluation and MIC evaluation in custody. Follow Rex. And there should be field visits 1 time per month until further notice. Probation, is there anything else? Is there anything else you need from the court in order to be successful?
No, Your Honor.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, Your Honor.
If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Keep your hands to yourself
Yes.
and do not get into another relationship until you find out what is going on with you and why you behave the way you do. You understand?
Yes, Your Honor.
All right, good luck to you. And are you Mr. Hurd?
Yes, ma'am. Yes, Your Honor.
All right, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it? Are you the same Darnell Von Hurd who was placed on deferred adjudication in 2021 CR 2260 for the offense of possession of a controlled substance, penalty group 1 gram to 4 grams on May 18, 2021 for a term of 2 years and extended for a total of 2 years? Is that you?
Yes.
All right, state.
Violate condition number 41 on or about the 23rd day of February 2024. In McGarity County, Texas, the defendant Darnell Von Hurd within a year failed to comply with the rules and regulations of the felony drug court. And never appeared for the court review or violation.
How do you plead to that? True or not true?
True.
Violate condition.
Any objection?
No, Judge.
Court will find violation of condition number 41 true. Did you I'm sorry. Did you understand by pleading true to violation of condition number 41, the court could find it true, grant the motion and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to violation of condition 41? Court will find violation of 41 true. Is there a proposed agreement?
Yes, Your Honor, to grant the motion, adjudicate guilt, revoke the individual's probation and sentence him for 2 years in Texas Department of Corrections.
Is that the proposed agreement?
That's correct, Judge.
Are you asking the court to follow that agreement?
Yes.
Are you waiving your right to appeal?
Yes.
The court will follow your agreement, sentence you to 2 years in the prison, find you guilty. Did you review the document entitled, and I'm sorry, there's credit for any time served and the court is going to request the therapeutic community. Is there anything else with regards to sentencing?
Yes, Judge. Just to make sure that the record reflects that the defendant has completed substance abuse programs in the past successfully. And we were,
The inpatient?
it was inpatient, Judge.
And what was that?
What was it? Setup.
And lifetime.
I think we request that he's credited with us at that time.
All right, you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, lower your hand, state your name for the record.
Darnell Von Hurd.
All right, why didn't you complete this successfully?
Self-sabotage. For the most part. And
Why?
um,
Why don't you want to be successful?
I wanted to be, but I just thought that I was still having trauma issues that I wasn't addressing, and the only thing that I knew best was to use.
So how old are you?
I'll be 60 years old this year,
And when did you first start using?
9 years old.
Okay. All right. You know, if you don't change things, drugs, whether they're prescribed or not prescribed, they wreak havoc on your body. And at least if it's a drug that's prescribed, if something goes wrong, somebody can still sue.
Right.
But if it's meth and all of these drugs that are not prescribed, who are they going to sue? The drug dealer? You know?
Yeah.
All right. Miss Abrams, I'll give him credit for any time served for successful completion of inpatient treatment.
150 days and 90 days at lifetime.
Okay. All right, I'll give you credit for that. So the court's entire ruling is the finding 41 true, find you guilty, revoke, sentence you to 2 years in the prison. I'm going to request the therapeutic community for you, give you credit for any time served and credit for any time served in inpatient treatment that was successfully completed. That will be 120 days for SATF and 90 days for lifetime recovery. Is there anything else from either side with regards to sentencing?
No, Judge.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Good luck to you. You're gonna have to change your ways. There are plenty of places that are free when you're released. If you can't find a free place to help you with any addictions or trauma you have, if I'm here, you can come back to this court and I'll make sure that you're in place with someone, okay? All right, good luck to you. Do better, all right?
All right, I will.
All right,
Judge,
bye-bye.
maybe excuse.
Yes. All right, and are you Mr. Ramirez? Did you review the documents entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and the state supplemental motion to revoke to enter adjudication of guilt and revoke community supervision with your attorney?
Sure.
Did you understand it?
Yes, Your Honor.
Are you the same one, Ramirez, who was placed on deferred adjudication in 2019 CR 8342 for the offense of evading arrest detention with a vehicle on January 16, 2020 for a period of 5 years? Is that you?
Yes, Your Honor.
State?
Yes, Your Honor, violating condition number 5 in Hurd County, Texas, against Ron Ramirez, within the mayor failed to report to the supervision officer as directed for the months of April 2024, violation condition number 5.
How do you plead to that? True or not true?
True.
Your Honor, we'll waive the related violating condition.
Any objections?
No, ma'am.
Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 5?
Yes, Your Honor.
Court will find violation of condition number 5 true. Is there a proposed agreement?
Yes, Your Honor, to grant the motion, adjudicate guilt, and revoke the individual office probation, sentence to 3 years in Texas Department of Corrections.
All right, is that the agreement?
It is our agreed recommendation, yes, ma'am.
Are you asking the court to follow that agreement?
Yes, Your Honor.
Are you waiving your right to appeal?
Yes, Your Honor.
All right, the court will grant the motion, find you guilty, sentence you to 3 years in the prison, give you credit for any time served. There's a $1,000 fine. Time and money to run concurrent. All right, I'm not the one who took this plea. I believe this plea was done before my time, but there's some sort of $25 fee Does anyone know what the $25 fee was for and did he pay it? Because it says a $25 PRO fee. Am I reading that correctly? It's outside the agreement at the bottom, but
I believe that was probation fees were lowered.
Oh,
probate,
okay.
yeah, PRO probation fee. That looks like initials.
All right, well,
It was lowered to the minimum.
Oh, I know who
Okay.
who that is.
Oh, but it was taken on my birthday.
It was taken on your birthday?
That looks like Pro V1. Which is my favorite golf ball.
Okay. All right, is there anything else with regards to sentencing?
No, Your Honor.
No, Judge.
All right, state you may be excused. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. How old are you?
29.
All right, so you're 29 years old. You had a chance to be in the free world and you chose to be on lockdown. Here's the thing, you're gonna have to start making better choices, because of what I can tell you, when I was 29, people never believe you're 29. They think you're fudging because they're thinking, no, you're really 30. You just hanging on the 29 for all it's worth. But I will tell you, every attorney who's in here and everybody who's in here, they will tell you, once you reach 29, the years just start flowing by. You're going to look up in 10 years of your life is going to be gone. And no matter how sharp the funding is for government, they will always find money to house people at the prison and at the jail. So it's your decision. You understand? All right. Good luck to you.
Thank you.
You're welcome. This is James McGarity. Can I have parties announced for the record for the state?
Megan Galloway for the state.
Marissa
Giovanco for Mr. McGarity.
And are you James McGarity? Counsel, have you received all discovery? Did you review it with your client?
Judge, this one is a little bit unusual. I have been Mr. McGarity's attorney on his aggravated assault case for some time now. However, the drug cases, Norma was going to add me to them this morning.
Okay.
So I have reviewed on the one we're taking a plea on. We have gone over the police report and the lab test. I have not received anything else. Mr. McGarity is aware of that. I did kind of add a stipulation to the discovery. He is willing, I'd like him to say that on the record, but he is willing to go forward and plea, knowing that there is still video evidence and a warrant that I have not reviewed. Well, the warrant's the same. So just the video evidence that I have not reviewed.
All right. Is that correct? And do you still wish to proceed?
Yes, ma'am.
Court will find that the state is in compliance with discovery. And was there a previous attorney appointed on this case or no?
No, Judge. It was just going to be indicted today or tomorrow, I believe. So we have reviewed everything, the lab test and everything, and we're satisfied with the plea on the case, but there was not a previous attorney appointed.
All right. And Mr. McGarity, have you reviewed the document entitled Waiver of Indictment, Reading of Information and Rights under Article 1.051 and 26.03 of the Code of Criminal Procedure with your attorney? Did you understand it and sign it?
Yes, ma'am.
Do you understand you have a right to have a grand jury hear the evidence in this case and make a decision on whether or not to hold you over for trial?
Yes.
Did you understand your attorney has certain rights? She has 10 days to prepare for trial and 2 days from the presentation of this information to proceed. Do you understand?
Yes, ma'am.
Knowing that, do you wish to give up all of those rights and enter into a plea in this case?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Did you review the felony information with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the information?
I do, Judge.
State you're proceeding on the information as presented? Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand by information you're charged with the offense of possession of a controlled substance penalty group 1, less than 1 gram? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine.
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Probation, there are no applications. Counsel, has your client been able to provide you with any defenses?
He has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do believe, yeah.
Do you believe he's currently competent and is legally sane at the time of the offense?
I believe he was.
Mr. McGarity, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 6 months in the state jail facility. The state will take in consideration 2025 PF 02499, and there's a $2,000 fine. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Judge. I would just like to be heard on that fine at the appropriate time.
All right. State, is that the plea? All right, Cindy, are you okay?
Yeah, I just need a drink.
Okay, go ahead, take a drink. Yeah. All right, did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Judge.
Then to the offenses charged by information, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
I have gone over, are you okay? I have gone over that with my client and we have no objection.
All right. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right. Did you understand again, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. You sure you're okay? I'm trying to get there. Someone gave me a flashlight, so. Okay. State. This is. Okay, thank you. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Judge, we are just asking if you could waive the fine, probate the, well, there's no probating the fine. If you could do anything with the fine, he is going into custody and does not have money to be paying that. I know time and money will run concurrent, but that's a significant fine in this case. We're also asking for credit for time served. I believe he has like 99 days.
All right, the court will, as previously stated, is finding you guilty. The court will sentence you to 6 months in the state jail facility. Give you credit for any time served. There's a $2,000 fine. Time and money will run concurrent. Take in consideration 2025 PF 02499. Is there anything else from either side with regards to sentencing? Defense?
No, not from defense.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargaining agreement, because I followed the plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record, and we're recessing for the day, and Cindy, you can go take care of that.
Oh, hope you feel better. for thing.
All right, so do better with your life, I understand? All right, good luck to
Each hearing in this video turns on the same point. Court supervision is not just paperwork. It is a test of whether a person can follow structure after the courtroom doors close. Judge Boyd does not treat these cases like routine checklist hearings. She asks what the record shows, what the defendant admits, and what conditions are needed next. In one case, that means strict boundaries and supervision. In another, it means a revoked opportunity and a sentence after a violation. The pattern is clear. A plea may open the door to a second chance, but the court expects follow-through. Comment which ruling carried the most weight, and subscribe for more real Texas courtroom breakdowns. Every ruling has a reason. Court Beacon TV shows you both.